Welcome to this edition of Northwest Real Estate Forum. I'm your host, Patricia Wangsness. Our mission is to bring you experts and relevant topics that will help you understand the art, science, and timing of real estate, because after all, your home is your biggest asset. Joining me today is Mark Schedler, attorney at law at the Williams-Kastner Law Firm in Seattle. Mark specializes in representing individuals and businesses in commercial and residential real estate transactions, and also acts as an arbitrator and mediator in disputes between buyers, sellers, real estate agents, escrow and title companies, just to name a few. Seattle Magazine and Seattle Metropolitan Magazine have both named Mark as a top lawyer. Welcome, Mark.
Thank you.
So today we want to discuss the Form 17. So that's a national federal regulation that everybody has to fill out, the disclosure.
Right.
And in our business, we, as representing the sellers, we go over it with the seller, and they're supposed to tell everything they know. And we've run into some problems recently about what a seller needs to say and what a buyer needs to understand. So maybe you could just give us a framework of exactly what the Form 17 is meant to do and what the seller's obligations are.
Sure. Primarily, the creation of the form is a Washington State story. And it was designed originally to help sellers remember important things about their time with the property that would help them decide what should be disclosed to a buyer and maybe what didn't need to be disclosed to a buyer, for example, where something's been repaired quite a while ago and there hasn't been any other problem. It started out as an industry form, and then the legislature adopted it, and it's made a couple of changes. So from the seller's point of view, they should look at it just that way. They should originally look at it as a reminder document to just help them remember their history with the property. And when it's time to fill it out, they should remember that there are really three choices: yes, no, and I don't know. Their answers are to be to the best of their knowledge and belief. So it's not like a warranty or an insurance policy that if the answer's wrong, there's some legal liability. But they need to be honest answers. So a seller needs to feel comfortable saying yes or no about whether the roof has leaked while they've owned it or something like that. But they should also remember that I don't know is there for a reason. For example, how old is the house? Maybe I don't know is the right answer because it's a pretty old house. And the statute that codified this form specifically says that the sellers won't have any liability for completing the form unless they were aware of an erroneous answer or an incorrect answer that caused a harm. And just because the answer was erroneous doesn't mean, again, there's an automatic liability. My point is that sellers shouldn't be too worried about this form getting them into trouble. Not all sellers have to give the form. Most sellers do. And you get a situation where somebody's selling somebody else's house as a personal representative, for example, in an estate, and then they should consult with their listing agent about just what their relationship with the property's been. And it might be more helpful from a marketing point of view to fill the form out, even though it's going to have a lot of I don't knows, than to simply refuse to give the form and then have to explain to a buyer why this property doesn't produce a Form 17 where a competing property does. From the buyer's point of view, they, in my opinion, should not look at Form 17 as a way of reducing the scope of their due diligence on the property.
Just because it says something, especially, we run into it a lot with building permits and
Right.
did the roof, did you fix the roof, and
Right.
minor things like that.
Correct. Right. The building permit is an interesting example where the buyer moves in, discovers that something wasn't done with a permit when Form 17 said the remodeling was done with a permit and final approvals. Now they find that they have to spend extra money to bring the property into compliance before they can do the next remodel that they wanted to do. And they think they've been lied to. But in fact, the seller's story is that they hired a contractor, they paid permit fees, And part of the job of the contractor was to get all those approvals, and the contractor just didn't do it. And most people who hire a contractor for remodels don't ask, where's my permit documentation or where's my final approval? So there's a great example of people sort of misunderstanding the purpose of Form 17. The purpose of Form 17 for buyers is to simply give them the answers that the sellers can give to the best of their knowledge and belief. And what that means is it's not particularly useful compared to the due diligence that they're going to do themselves. And they shouldn't choose not to hire a video expert or a plumbing expert or an electrical or roofing expert simply because of an answer on Form 17.
Well, we are going to have part 2 of this conversation, and that's going to be exactly what the buyer does when they find out something is wrong with their Form 17.
I look forward to it.
So thanks very much, Mark. Thanks for watching part 1 of our conversation with Mark Schedler. Tune in next week to hear the rest of our conversation. I know you will get a lot of really important information. To learn more about this and other shows, please visit us at northwestrealestateforum.com or check us out on Facebook. While you're there, be sure to order your free copy of Neighbor Law, Fences, Trees, Boundaries, and Noise by Kara Jordan. You'll be surprised at what you learn. I'm your host, Patricia Wangsness. See you next time.